Okay, and we're going to call for a reconvening of the Planning Commission meeting. And at this point, we were correcting for the record officially that Kazuki had made the motion and Hargreaves had seconded. And then the motion passed.
Okay, perfect, thank you.
Yep. Okay, and then at this time, this is the opportunity for members of the public to participate in open forum. It's for members to address the commission on any item that's not already on the agenda. The open forum is an opportunity to be heard, and it's not an opportunity to debate an issue, but to bring an issue to our attention. I just want to do a quick reminder of the rules of the decorum of the Planning Commission meetings. Those who are not recognized by the chair should refrain from commenting, interrupting a speaker at the podium, conducting conversations with other members of the audience, or creating any other type of disruption, causing distraction to a member of the commission. This will be enforced throughout the meeting, and those who fail to abide by these rules will be asked to leave. Comments are limited to in-person participants, and speakers are asked to fill out a card prior to the start of the meeting for Natalie to call them up to the podium. Written comments submitted prior to the beginning of the meeting will have been distributed and read by the commissioners up at the dais. So if anybody sends in an email or something about an issue, that would be available to us up here. And I don't see anyone here tonight in the chambers for making that public hearing or public comment. So that being said, I will entertain a motion for us to close the public open forum.
I'll second that.
All those in favor?
Aye.
Okay, and so then we're on to the approval of the minutes from the June 6th meeting. Is there anyone who had any corrections or comments regarding the meeting minutes?
I don't know if it was omitted because it on purpose or not, or if it should be included, but the one thing I missed in the summary of the discussion on Upward Acres was the comment and noted neighbor feedback on the naming. That was the only thing I think I missed in there.
That's good. I remember that being a point, and I think that because it's really only application, because they said that they weren't doing any signage.
Okay.
So it won't, the name, so I don't know
It's not a
that
big
it,
deal, but
yeah, no, it's a good point, but I don't know that it would need to be noted anywhere other than, possibly.
We can certainly add that into the paragraph, the summary paragraph.
yeah, I don't know. Up to you. I know you had talked to the neighbors and that was a comment. I just realized when reading through it, I didn't see that reflected, that's all. So I'll leave that up to you.
Okay. And then my only note was that in the very first paragraph, the second sentence, it says that 3 planning commissioners were present, but there were 4.
Okay.
I don't know that that matters either, but.
Yeah, we can make those corrections, so the motion could just be approve the minutes with the noted corrections.
Okay.
Staff will fix those 2 items.
Perfect. Okay, so I will make a motion that will approve the meeting minutes from June 6th with the noted changes. Anyone?
A second.
Excellent. And all those in favor, say aye.
Aye.
Anyone opposed? All right, and then we're going to move on to the new business, which is a self-storage zoning ordinance amendment. And there is going to be a public comment opportunity, but we're going to begin with the staff report.
So yes, our one public hearing tonight is for a zoning ordinance amendment to remove mini storage and self-storage from our commercial and industrial districts. So over the past several months, the city evaluated mini storage and self-storage uses within the city, and then direction was provided to staff to go ahead and proceed with removing these uses from our rural commercial and light industrial districts. They're not currently allowed in any other districts. There was a moratorium on new applications that was adopted on October 12th, 2023. And it was applicable to any new applications for mini storage and self-storage. We specifically exempted applications that had at least preliminary approval before. So specifically, we have a planned unit development for the Pioneer Trail Industrial Park, where part of the preliminary approvals, they were showing a self-storage user, they were exempt from the moratorium. And staff, as part of this process, completed a brief study of the current approved and constructed storage in the city, as well as Greenfield, Rogers, and Medina. The table shows comparatively, we have about 60 acres of self-storage, and Corcoran has nearly 20 acres more storage than the 3 other cities we looked at combined. And so the council confirmed a desire to diversify the types of businesses that can be developed on our remaining available land in the commercial as well as industrial areas, and then as well as promote a diversity in our job opportunities. So it's a fairly straightforward ordinance in front of you tonight. In section 1040.090, which is our rural commercial district standards, we are removing paragraph H in subdivision 4. And then in the next section is section 1040.125, which is our light industrial district standards. Subdivision 4, we are completely removing paragraph B. And then I want to also note section 3 of the ordinance. We're talking about the ordinance effective date. As part of that, I specifically clarified that storage projects not constructed but that have at least received preliminary approval are still allowed to proceed. The intent wasn't to take away a previous approval, it was to, as we move forward. So that would apply to Corcoran Storage 2, and then again, that Park Place storage that was shown, the Pioneer Trail Industrial Park PUD. And so at this time, the Planning Commission should open the public hearing and take any testimony. Staff recommends approval of the draft ordinance, amending those 2 sections, and then a draft resolution with the findings of fact to support the zoning amendment.
Okay, thank you. At this time, we will open the public hearing. Comments are limited to in-person participants. Speakers may fill out a card prior to the start of the meeting for Natalie to call you to the podium. Submitted comment cards will be called to the podium first, and then after that, anyone else wishing to participate may approach the podium. Written comments submitted prior to the beginning of the meeting will have been distributed and read by the commissioners. There were no comments on the dais for us this evening. There is no one here, so I'm assuming we have no comment cards, but I'll just verify.
Correct.
Okay. So at this time, then I will also entertain a motion to close the public hearing.
I'll make the motion.
All right, and I'll second. And all those in favor?
Aye.
Aye.
Okay, and then we get a chance to discuss the storage amendment. If there's anything that you guys would like to have discussion about. I know it's something I believe that has been discussed. I know it has when you guys have been here, and I believe it has been discussed at least once while you guys have been here.
I do have a question.
Absolutely.
Are there currently mini storage projects that have been approved that haven't been constructed yet?
You got Corcoran Storage 2, which is on Highway 55 in our southwest corner. It's on the border of Greenfield and Corcoran. And then Pioneer Trail Industrial Park PUD has had a site about at least 10 acres of storage, and the user identified with the application was Park Place storage going in there. And I spoke with that applicant today because he got a little nervous when he saw, and I assured him that the way that the ordinance is written, that they would be exempt. Technically, that land is re-guided as PUD, so I don't believe it's going to create a conflict that the light industrial is now removing that use going forward.
Okay.
Is that the one on Pioneer Trail? It doesn't have a street name on this page back
Yeah, it is the
here. Oh,
there is
it
a
right there. at
Yeah, Pioneer Trail Industrial Park. Yep.
Are the numbers in the staff report reflective of those 2 projects?
Yes. Yep.
Okay.
So that's all. So that was everything approved and constructed in the city of Corcoran, and
I
then we reached out to other cities, and they also gave us their approved projects in addition to constructed projects.
May I, do you still have some questions?
No,
Is that the-
no, I was, you.
Oh, okay.
You had this question I was gonna ask too about.
Oh, okay. Does council, or like, is the sentiment that we feel good about the percentage? I mean, you know, the statements of like, it's more than other cities combined, it's like, wow, okay. And I know I've heard council's comments of we don't want to be known as the city known for storage. I guess my question and maybe it's hard to answer, is are there learnings from this? Like, are there, you know, this was something we maybe did too much of, and now we're taking it out completely? Like, what might we be missing that we're doing now, or we might do in the future that will be in the same situation? So I'm curious, like, are there
Yeah.
learnings, best practices? Like, how did this happen? I'm curious of that.
Yeah, so it's difficult to have a crystal ball to say, okay, this is now the new storage use. I would say that we're not the only city that has decided to stop allowing mini and self-storage. It seems to be a use that has really taken off market-wise in the last decades, or a couple decades or so. So I know
Okay.
Brooklyn Park made it so that they only allowed indoor storage, especially along key corridors in terms of where they've identified as job creation zones, or it's really a key part of their identity, and so they don't want that on that road. And there's at least a couple other cities I'm aware of, I just can't think of the names right now, that have completely removed it as a use. So we're not the only ones.
Yeah.
Typically the findings of fact are the fact that it eats up a lot of our available industrial and
Right.
commercial land, and then the return on jobs is minimal. In terms of, but then if you have a warehouse in that same pocket of land, you have a much significant job return, much more significant job return than you do with the storage.
Right, right.
So I do know that, I think with some of the other industrial and commercial uses, it's less of a concern because we're not seeing them eat the footprint as much. And with the ones that do have a bigger footprint, there's typically a better return on the job part, whereas this one tends to not see that return.
Sure.
They're great for tax base. So it's not that they're, and we've kind of weighed that with council, is like they are great for tax base, but they are, if you're trying to have jobs in your city, they're not so great. And right now, that's one of the areas that we need to focus on. And so I think the idea is maybe in the future, we could allow for it again if we wanted to change our mind, but right now, we want to stop the incoming applications because they just keep coming, so.
Do we feel like we have so much more than other cities because they were the first applications to come and we, like, do you
I hear
understand what
you're
my
saying.
question is?
I think that what your question is how can we prevent ourselves from getting where we have such an extreme, we have so much gross land devoted to one purpose. How do we keep ourselves from being in that position again in the future with a different
Correct.
use? And I think that there were, I can't say for certain, but I think that there were inklings like a while back that we probably had to, like, we had more maybe than was needed. And so I think maybe the learning is that if there's sort of a gut check that's like, hey, really, we're seeing a lot of this, it would be a good idea to do this process where we ended, where we're comparing ourselves to other cities earlier than now.
Right, well, and sometimes too, I think it's like, it's not necessarily a bad thing if the uses are meeting your goals. So if your
Sure.
goal is job creation, and you're seeing a lot of a particular use, in terms of like warehousing, that's kind of a general, it's such a broad word, that there's a lot of different types of businesses that can go in there, and then they're typically, you're gonna see a job return. So if it's hitting your goals as a city, it might not be so concerning. I think part of the concern here wasn't necessarily hitting our job creation goals as a city, so.
Are there other types of businesses that we could see becoming a problem? And I'm thinking in particular like dollar stores, Dollar General. I mean, you see those in rural areas along with the mini storage. You see that every little small town has mini storage and it has a Dollar General. And I guess the Dollar Generals, because they tend to crowd out other things that may be more desirable.
So we can't put in the zoning ordinance no Dollar General. It would be no retail. And so that's all, it creates a larger problem, because I think we do want retail.
We do want retail.
So, but it can't be so specific that we're saying no McDonald's here. You would have to say no drive-thrus, things like that. It has to be a broad use instead of a specific business that you're looking to avoid.
I think your suggestion, Corinne, was great, right, about maybe that's a learning. And I guess I'm curious, do you agree with that?
We can always look at uses if we believe that there's a problem. I would say if we're seeing a use that we don't feel meets our goals, our development goals, our economic development goals as a city, then yes, we should take a pause and take a look at how that aligns with our overall vision for the city.
No, but I appreciate the amendment. I think it's great. I appreciate you taking action on it. I was kind of thinking the bigger picture of like, I wasn't here when they were all approved, and I was just curious if we're happy with the statistics or what we thought happened, or like what, just the background on it, so.
My only question is, the two areas that we're addressing tonight are the commercial, rural commercial and light industrial. It is not necessary, it's not an allowed use in the transitional commercial rural, or no, that's
No.
interesting to me.
The transition rural commercial is technically a residential district.
That will eventually become zoned commercial if
Yeah,
commercial
it's kind
business
of
is
a
going
holding
there.
zone in the
Yes.
same way that
Okay.
urban reserve is a holding zone.
Gotcha.
Yeah.
Yep, now I remember that. And then the second question, and I don't want to panic any applicant who's been approved, so this is not, but there is no expiration date on those approvals.
There is an expiration date on those approvals.
But it just follows
But
the,
so they had to submit a final plat application, that they did, and
Okay.
we're working through that with them. We were expecting that to go to council in hopefully the next month or so for the first final plat. So as long as they keep the ball moving
Their
on their
timelines.
end, there should be,
Okay.
but yeah, theoretically, there is a date where.
there's a process that would say, hey, now you've dropped the ball.
But yeah,
versus- okay.
yeah, but I don't, the applicant is actively working on it,
Okay.
so I don't think that's a concern at this point.
Okay, those are my questions. Does anyone else have anything? If not, I'll entertain a motion to approve the City File 23-023, which is the mini storage and self-storage ordinance amendments.
A second.
Okay, all those in favor, I will make the motion, and then there's a second. And then all those in favor? Aye.
Aye.
Anyone opposed? Okay, next up then is our other business, and we're gonna start with Planning Commission training, which is why you all have colored buttons at your station. And Natalie is gonna take us through a fantastic training. I hope you guys enjoy it. It's quite fun.
This is
As far as
exciting.
training goes, you know.
Thanks,
it's fun.
Natalie.
So, two of you, this might be a little bit more of a refresher than anything new, but because we have 3 brand new commissioners this year, I wanted to make sure that we have a chance to go over the basics. And then I think what will be fun is the Jeopardy round that we'll play at the end to go over the concepts talked about in the presentation. And then if we need more training opportunities this year to do deep dives on other topics, we can certainly try to get that scheduled. So, but yes, so for starters, I like to start with the historical basis of planning because I found this really interesting. The concept of city planning resulted from the Black Plague in Europe when a quarter of the population was lost. They realized the dank and crowded living conditions resulted from how the cities and buildings were built, and it contributed to the spread of the plague. So as a result, England implemented rules that all living units needed to have access to light and air, and additionally, we saw rules that animals were separated from human living spaces for the first time. And so that, I just found that to be really interesting when I learned about that. And so that is really the first time you started to see regulations established that tried to make our living conditions better and to plan that out more thoughtfully. And then additionally, the Industrial Revolution also had a role. People started to become sick and die as a result of the smoke and soot during the Industrial Revolution, as their living spaces were not separated so that you would see houses directly adjacent to this heavy industry. And so this is the first time we start to see the use as zoning, because residential uses all of a sudden needed to be separated from industry. So that is kind of the basis of how we started to get here. And then our planning authority is based in the Constitution and falls under police powers granted to the states. Police powers specifically refer to limiting an individual's rights in the interest of the community. And the key constitutional principles that must be kept in mind while we are planning is due process. This means both substantive and procedural. So we have to have a rational basis for the decisions that we make. And then procedural, meaning we have to be reasonable and follow a prescribed process. This is public hearings, which is a specific role that you have on the commission, is to hold our public hearings for land use items. Additionally, another key constitutional principle is the equal protection clause. We have to treat everyone the same within the district. So kind of back to the conversation we had. If we say that we allow retail, we can't say that, well, this business isn't allowed, but this one is. We can limit aspects of it in terms of drive-through. We can say, we want restaurants, but we don't want drive-throughs in this district. And so that would be the equal protection clause in play. You can't favor one business over another, and one property owner can't be treated better than another. Also, we have the principle of takings. The taking of property for public use requires just compensation. We do have a couple exceptions. So the government can take or require dedication of public right-of-way for a road within a plat or public process without paying for it, because it is generally a basic requirement to serve the properties within the plat. So that's how we take right-of-way when we have a new subdivision, because it's necessary to serve those houses in that subdivision. Additionally, state law allows us to take parkland and park dedication in lieu of land in order to provide open space opportunities and recreational space opportunities for the city. Zoning regulations that are not supported by rationale or are unnecessary can become a taking. So for example, a front yard setback of 100 feet without any rationale behind it could be considered a taking as compared to a more typical setback of 20 to 30 feet. We do have an example of a 100-foot setback in our ordinance, but the reasoning being these are our county roads where we are seeing more and more right-of-way eventually need to take that area to support those highways. And so that 100-foot setback provides for not only green space, but it also provides some wiggle room for buildings so that as the road expands, there's still significant space left. And we also provide a flexibility clause to bring that down to 60 feet. So that's, it's not always a taking when you have a big setback, but you want to make sure you have rationale behind it. So again, make sure you have a rational basis for zoning regulations and that you're treating people fairly, reasonably, and equally without putting a burden on property owners beyond the government interest. And so this is another historical timeline. So you see the first land use regulations were established as public health laws in England and regulated light and circulation. Prior to 1916, nuisance laws were used to protect the public health, safety, and welfare. We still have nuisance laws. So I am the code compliance official, and that power is rooted in our nuisance laws. And then I am the zoning administrator, and that power is rooted in our zoning ordinance. So we still have those today. It's just, it's only one of the tools that, or we have multiple tools now. 1916 is when we start to see the establishment of early zoning laws as we know them today. New York City was the first city to adopt a comprehensive plan and zoning ordinance. And then in 1922 was the first version of federal legislation for the Standard State Zoning Enabling Act. 1923, 208 U.S. communities had adopted a zoning ordinance, so those first 1916 to 1923, so that first 6 years or so, 7 years, people were busy. And all of a sudden there started to be planning and planners and planning commissions. That really happened with it very quickly once we had that enabling act from the federal legislation. And then in 1826, the U.S. Supreme Court upheld the use of zoning as a police power in the case Village of Euclid versus Ambler Realty. And that's where the term Euclidean zoning comes from, is that case. So why do we plan? The planning process evaluates the community's past and provides a vision for the future. And through planning, the community can anticipate how to protect our community character and resources, drive economic development and investments, provide cost-effective delivery of services, participate in intergovernmental cooperation, and balance the community interests with private property rights. And then a quote by E.K. Schumacher, I guess I don't know exactly how to pronounce his name. Schumacher, thank you. Among material resources, the greatest unquestionable is the land. Study how a society uses its land, and you can come to pretty reliable conclusions as to what its future will be. Minnesota, we have enabling legislation where the state delegates the police power to local government units through the statutes. So our authority is Minnesota Statute 462.3535. That is for all cities and towns. And then there's also some additional enabling legislation for metropolitan area local units and counties. But a lot of what we're looking at is that first statute for our purposes. And then we're going to talk a lot about guiding documents. So the enabling legislation requires planning to begin with an analysis of community needs and goals to formulate a comprehensive plan. That is really the basis of everything that we do here. And then the comprehensive plan acts as the guiding policy for community development, including the zoning ordinance and other land use regulations, such as our subdivision ordinance. So basically the zoning ordinance and subdivision ordinance are the tools we use to implement the comprehensive plan. And then the supporting rationale of the zoning ordinance should be provided by the comprehensive plan, and regulations must be, again, reasonable means to meet our legal ends that we've identified as our goals. So the zoning ordinance regulates private property by establishing standards of development for individual lots, the use of land, and buildings within the community. This works in conjunction with our zoning map. And so it determines different classes of uses. We have allowed uses. These are, and it's really permitted uses, and these are almost no questions asked. The conditions cannot be applied. You are allowed to do this by right. So for example, in our rural residential district, agriculture is a permitted use. You do not need to come and ask for any type of permission from the city to be able to use your land for agriculture. You may have to go through a permitting process or a certificate of compliance process to develop a building for your agricultural use, but you can go and farm your land right this second. And then we have accessory uses. So these are permitted uses, but they must exist in connection with a principal use. So for example, a accessory structure such as a shed, you cannot have in the city without a house. We have a lot of people who would just buy land and want to put a pole barn up. You have to have a house first before you can have a pole barn or other accessory structures, how we've identified them. And then conditional uses are an allowed use. However, it's been called out as a separate category because they often require additional stipulations to ensure it fits within a given area. So we can mitigate the impact of a use. For example, a place of worship going in a residential area, there might be additional conditions that we want to stipulate in order for that use to fit within the surrounding neighborhood. Interim uses are uses that can be approved for a limited amount of time. An example being we have home occupation licenses, and when there's separate categories of home occupations, but the highest impact require an interim use permit. So the idea being when this property owner either sells or no longer does this business activity anymore, that permit would go away. It doesn't get automatically transferred to someone buying that property. And then we also talk about bulk and area regulations in our zoning ordinance. So we have height, setbacks, lot coverage, impervious surface limits. We have performance standards such as landscaping requirements, parking requirements, etc. And then our subdivision ordinance is what establishes the procedures for land division that is consistent with our comprehensive plan. It ensures new development and redevelopment meets standards for a safe, functional, and enjoyable community. Subdivisions equal the division of a parcel of land. So sometimes, so it can be as small as a 40-acre parcel being split into two, or it can be a 40-acre parcel split into 120 homes. and they're all referred to as subdivisions. So again, lot blocks or sites with and without streets, those are going to be regulated in the ordinance, and these are needed in order to sell, transfer, or develop land. And we also have this term plat, where if you try to look that up, you might not actually see like, what is a plat? But a subdivision results in a plat. One way to think about it is a map of the plot of land, but plat is the specific term for those maps that we see on the Planning Commission when we are subdividing. Role of planning staff and consultants. So my job and Dwight's job here, and then as well as Landform is our planning consultant. We are tasked with interpreting and administering land use regulations as provided in the city code. We complete the technical review of land use applications. That is a process that can take hours upon hours. So you are not expected to do that yourselves. And then we also are expected to meet with developers, property owners, and residents to discuss their land use questions and vision for their land. We prepare staff reports to inform and advise the Planning Commission and City Council. We research planning and land use issues, such as we did with the storage. We draft long-range plans and special projects. Example of these long-range plans not only are the comprehensive plan, but our Northeast District Plan, our Southeast District Plan. We maintain city records. We provide continuity and institutional knowledge. And then we educate and assist the public. Some people say the voice of planning at City Hall. I took that from somewhere, I didn't just make that up. So. But consultants also, it's important to know that they serve at the pleasure and direction of City Council while working closely to coordinate land use items with city staff to inform a recommendation to council. So any recommendation that's coming from a staff report prepared by Landform is something that has been discussed at length with myself, likely the city administrator, and engineering and our public works director. So that staff recommendation, when don't consider, well, that's Landform's recommendation. No, that is reflective of the staff recommendation. They don't do anything that is not pre-approved by myself. And they provide their professional advice and insight based on experience with working for other cities as well as developers. And they provide services that the city may not have easy access to, such as additional staffing and software. So when we have an influx of applications, we can't simply go out and hire a new planner to deal with that temporary situation. So we rely on our contract because they do have multiple staff members at hand that are able to take on to help us get through that period of time. And then also, for example, when I was working on the survey for the rural commercial subdivision, it became quite clear I didn't have proper software to create the visuals that I need to create. Word just wasn't cutting it. And they had InDesign, and so they were able to, instead of me trying to get an InDesign license, which is expensive, and then try to learn InDesign in a matter of a couple weeks, they were easily able to get that up and running within 2 business days. So they provide those resources that when it becomes clear, like, oh, I don't have this, it's going to be a minute before I can get it set up, they're able to help provide that backup. So the City of Corcoran does not allow our planning consultant firm to submit a land use application on behalf of a developer for a property within Corcoran. So that's not true in all cities, but that is part of their contract. So Landform is never going to submit an application on behalf of somebody else. So I think that's just helpful to know. Those are some questions that have come up with how does that work with Landform. We do really, the institutional knowledge that Kendra specifically has is invaluable at this time. And I wish I could just kind of put a hard drive into her brain so I could get all of that, but she has really helped guide and shape our ability to respond to the land use applications and development that we're seeing right now. So she's been key to that. and remains significant, but we are starting to see her slowly. She's no longer at these meetings. If you
That's what I was gonna
so-
say. I just wanted to interject. Do you guys know who she's talking about when she references Landform and Kendra?
Yes.
Usually you'll see her at the council meetings now, but she
Yes.
used to be at every commission
Yeah.
meeting. But
We
that
are-
was before.
We are
Brian.
transitioning away from her being the main planner. She was really the main planner for a long time, and we are slowly starting to transition away from that. I hope that she will be here for a few more years so we can get, again, everything that's in her brain. But the plan at this point is to continue strengthening our capabilities. I'm hopeful that we'll get some more software capabilities so that I can take on things like InDesign. But it's still sometimes the workload is so heavy that typically all cities have some type of contract planning in the back of pocket to be able to pull from as needed.
So that you can meet the legal timeframes that are
Yes.
required with
Yeah.
applications.
So Natalie, you've become the community development coordinator?
Director, yes.
Director,
Yep.
yes.
Yes.
So, and then there's another planner that's taking the play. Is Dwight stepping into that role, or?
Did you put your application in yesterday?
Application's on the way.
Application's on the way.
Okay.
So yeah, we're working on that.
All
It
right.
was an internal job posting. So I would say that it's anticipated that that's going to be what happens. I will still act as the principal planner, but with the additional duties, I simply am not getting to everything. So we do need a second planner. And then I hopefully will, in the next year, we'll have an administrative assistant for community development overall. And then that should really get us to a point where we're operating efficiently to be able to meet the demands.
One more question. So we still have a contract with Landform?
Yes,
And,
yep,
and they are still available to help you out as needed?
yes, yep.
Can I ask another question too? I know that the mayor put out kind of a warning about Minnesota legislation and like some of the proposed changes to a
Mhm.
city's ability to manage its own development.
Mhm.
Do you see any feedback you'd give us as far as what you're seeing and what that means for planners?
Yeah, so none of it went through this year.
Okay.
It got really close. It's actually, this is at least the
Third
third
year.
year in a row where something kind of pops up along these lines. This one was probably the most drastic and concerning of the 3 years, and probably the closest it's gotten. But cities, pretty much every city I'm aware of really pushed back against it, and even the Met Council was like, this is too much density, this doesn't make sense, we can't regionally plan for this. So thankfully, it did not go through at this point. I'm going to a session, a sensible land use session later this year that is, I believe they're trying to get a couple of people who were behind those bills to speak in terms of what we can maybe anticipate next year coming back. So I would just say, stay on top of it, make sure that when legislation, pay attention to who you're voting for. While I am very pro making sure we have housing, I don't think that was the way to do it, personally. Just because of the fact that, to me, it doesn't make sense that we're planning for density that we can't accommodate, we don't have the infrastructure for as a city, and that was the problem. The main problem with that is it really was for cities that have existing infrastructure, and we simply don't. We're very new in terms of being able to implement some of that, and it simply could have been a disaster.
It also would have removed a lot of the role of the planning commission, and so when she
Yeah.
touched on earlier that the Minnesota statute 462.3535 is all about empowering the people to have a voice in the planning process, it would have removed that. So I think that there would be significant, grounds for really, if it ever passed as extreme as it was, there would be grounds for really questioning whether or not it infringed on people's rights at that point in time, so.
Thank you.
Yeah, so we'll definitely keep you posted. I would say at this point where we can take a deep breath, and then next year just pay attention to it. And the letters they received, the pushback they received from cities played a significant role in that not going through this year, so. So then we get to the role of the Planning Commission. This body is created based on the presumption that residents should be involved in the review and recommendation of land use applications and regulations. You are expected to host public hearings for development applications and regulations. That is a significant part of your role. The idea is we host the public hearings, that it gets to council, it allows for a more efficient business meeting with the city council. And so it's important that we provide this format for those to participate when they have concerns, or even to state their support in instances. Like we have seen some, the recent PUDs, they mostly received some significant support. And that was really cool to see, because typically PUDs you don't see support. So, and then the commission mostly makes quasi-judicial recommendations to council. This means interpreting and applying the ordinances as they're written. And then you'll also make some legislative recommendations to council. So these are changes to the zoning ordinance like we just processed. And you'll also be a part of our comprehensive planning that's expected to kick off potentially in 2026. And so that would be your legislative authority. So again, the Planning Commission interprets and applies written codes and ordinances. Planning commissioners are not expected to complete their own technical review. That is a process that takes hours. That is why you have engineering staff and planning staff to take care of that, so that your focus can be on how an application does or does not fit within our adopted ordinances, and provide feedback on areas where there is a matter of interpretation or city discretion. I did want to take a chance to just go over the city's mission, vision statements, and Corcoran values. The mission statement for Corcoran, the city of Corcoran will provide high quality public services in a cost-effective, responsible, and professional manner in order to create a preferred environment to live, work, play, and conduct business. So this mission statement is why our organization exists. And then the vision statement being where we want to go. The city of Corcoran will become a vibrant, connected community while preserving its natural character and agricultural roots. And I would say that this is heavily reflected in our comprehensive plan, and therefore also part of our zoning and subdivision ordinances. And then we have values such as honesty, ethics, integrity, community pride and partnership, efficient and effective service delivery, community safety, fiscal responsibility, transparency, and responsible decision making. There are explanations, these are all on our website, but these are basically the fundamental culture and actions significant to our success and fulfillment of our mission statement. And then we have some core strategies. We've adopted these strategic goals to reach our short-term priorities, so enhancing Corcoran's sense of place and identity, providing diverse community amenities and recreational opportunities, maintaining excellence in safety and security for our community, ensure high-quality market-driven growth, and provide high-quality innovative municipal services. So I would say community development is part of all of those strategies. So we have a lot of work to do. All right, so then we can transition here to the types of applications within the Planning Commission's purview. You will be seeing applications for comprehensive plan amendments, rezoning, zoning or subdivision ordinance amendments, preliminary plats, preliminary planned unit development plans, conditional use permit, interim use permit, variances, and site plans. I think the slide is really interesting. Talks about the pyramid of discretion. So again, the legislative functions that you provide on our comprehensive plan, our zoning and subdivision ordinances, this is where the city has the most discretion. These are really, when we talk about these application types, these are really where we're asking for detailed feedback or detailed thoughts, because we have much more ability to say, no, we don't like this. Or yes, this is in line with our vision, our goals, our values. And then the next step up are subdivision applications, conditional use permits, and variances. These, and actually, I don't agree with the variances though. The variances should be red, so just pretend that's red. Oh, no, I'm sorry, green. Variances should be green. So subdivision applications and conditional use permits. This is not my triangle, to be clear. It's someone else's triangle. Maybe we can do
With
that
the
in-
right software, you can make
Yeah,
your own
exactly.
triangle for
Maybe-
next year.
Maybe I can, with InDesign, I can fix it for next year. But subdivision applications and conditional use permits, so these, there is some discretion. We have some ability to say this doesn't fit, but we are applying the written ordinance for these application types. Variances are a little tricky, so we do have standards for variances, but the practical difficulty standard that you have to meet is really a matter of interpretation at times. And the thing with variances, we'll get to it a little bit, is that the applicant, the burden of proof is on the applicant. So the city can say simply, you haven't met that burden of proof. And as long as we have findings of fact to support that, which are relatively easy because we don't have to approve a variance that we don't like. So that's why it's more green than yellow, and I would change that with some software. And then the red is our plan review and building permits. So building permits are not going to be in your purview. That is completely done administratively. We have some other examples of that too, where the council and planning commission recently gave staff some more administrative authority with a couple different items, such as wetland waivers are now completely done administratively in conjunction with our city engineer. And then we have administrative permits for accessory dwelling units. If they meet certain standards, they do not need to go through the planning commission and city council for authority, for approval. And then we have, I'm trying to think if there's another example. Oh, for legal non-conforming expansions for some structures, if they meet certain standards, again, we've outlined a process where that can be handled administratively. So that's really where we're checking a box and stamping it, really making sure that it fits those standards and then going through. We do not have any other discretion. We can't attach a condition to a administrative permit that isn't specifically to say you need to make this change so that you meet this condition. We can't add a new condition. Site plan review is something that does still come in front of you as the planning commission, but again, it doesn't meet these standards that we've outlined in our landscaping standards, doesn't meet our parking standards. If it does, it's an approval. We can't add a new condition unless there's a conditional use permit as part of the application. So a little bit more detail on the application types. So comprehensive plan amendments. We have criteria to consider when reviewing amendment requests. So they have to have consistency with the overall goals and objectives of the comprehensive plan. We have to consider impacts on public facilities and services such as roads, sewer, water supply, particularly if the impacts cannot be mitigated. We have potential for resulting development to create an undue impact on adjacent properties. And then we should consider development should fit the physical character of the neighborhood or improve viability. So these are just, again, some of the criteria to consider when someone says, hey, I would like to re-guide my land from single-family residential to medium-density residential, as an example. One that we actually have seen recently was actually the other way around. They wanted to go from low-density residential to an even lower density, and we created a new category for that. So that are the comprehensive plan amendments that we're seeing right now. But anyone that's a property owner can request to re-guide their land, and we just have to, as a city, decide, does that overall fit our goals? What are the impacts? And then we can decide, yes, we agree that that change makes sense, or we can say, nope, we want to stick to our plan. And then for the zoning ordinance amendment, this is a change to our zoning ordinance map or text. So a map amendment changes district boundaries, And then the text amendment changes the district regulations, so allowed uses, setbacks are examples. This, again, is a legislative decision, but it must be consistent with the comprehensive plan. So if a property is zoned single-family residential and they want to rezone it to commercial, they cannot do that without also amending our comprehensive plan to re-guide it for commercial. So it has to be consistent overall. And zoning ordinance amendments should not have a detrimental impact to the immediate neighborhood or community as a whole, the natural environment, and with the caveat that mitigation can address some of the natural environment impacts. But it shouldn't lead to a situation where you're having unexpected, like in the middle of, I'm trying to think, like in the middle of a conservation area that we've identified, you wouldn't want to re-guide or rezone an area as light industrial, something like that, where there is potential for a bit more pollution. And then the city's ability to provide efficient public facilities or services. So this kind of comes down to the whole argument of MUSA requiring 3 units an acre. 3 housing units an acre to allow us to provide efficient and public facilities and services for sewer and water. And then when you go into our rural side of the city, that density changes to 1 in 10 because you either want really clustered together housing or you really want large land to be able to provide efficient public facilities or services in the future is the idea there. So that's some of the factors that go into play when we're considering our zoning ordinance amendment. We would not want to put 3 units an acre in the rural side. It simply would not make sense right now. And potentially it would never make sense if we don't have the MUSA line change.
Would you consider that like spot zoning or that term? Like, can you speak to that? Has the city encountered stuff like that?
Actually, the next slide, we talk about spot
Okay.
zoning a little bit. But yeah,
Okay.
spot zoning, it's kind of this abstract concept. But the idea being, when I've talked to the city attorney about it, spot zoning, it's not necessarily like that, oh, well, I've guided this property over here, or I've zoned this property over here commercial, but there's residential next to it, that's spot zoning. That's not quite what it is. What spot zoning is an incompatible zone in the middle of a residential area, for example. So to put a nightclub in the middle of Bellwether, and you have to rezone it so that you can allow that nightclub, that's spot zoning. So yeah, zoning a single piece of property out of context with its surroundings. So you can still have like a small area that's zoned commercial in a residential area. Typically, it's going to be at the intersection of 2 busier roads. That would be an example of where it wouldn't be considered spot zoning to have residential next to commercial because it's compatible with its surroundings. It supports that type of use because of the heavier volume roadways that are able to serve it.
Oh, yeah.
Yeah.
That helps. And I see it here now, too. Sorry, I was just
you're
a
fine.
step ahead. Okay.
I'm glad that was a natural transition. So, yeah, so for rezoning, again, this is the land, we talk about a zoning ordinance amendment for MAP. We also call it rezoning. So these are land use decisions, again, that must be consistent with our adopted comprehensive plan and our future land use map that is within our comprehensive plan. If the requested zoning is inconsistent with our comprehensive plan, then the commission should recommend denial, unless there is a general agreement that the rezoning is location appropriate and beneficial, and then we would go through the process to do that comp plan amendment. Typically, by the time it's in front of you, they've already had these conversations with staff, and they know that they'd have to do a comp plan amendment, so you'd be seeing it at the same time, unless someone was being really unreasonable and didn't want to work with staff. But so far, that hasn't happened to the point where you guys have seen an application out of context like that, or out of sequence like that. We try to do it all at once, or it would be a multi-step application where the first step is that re-guiding. The next one is preliminary plats. We'll see this quite a bit. It's preliminary and final plats are the subdivision process, but you will typically only see preliminary plats. Because the final plat is simply the exercise of saying, yes, you met all the conditions of the preliminary plat. So plat approval can only be conditioned on specific things, because again, this is where we enter into that yellow area of discretion where we have less discretion. It's really about how it meets the letter of the law. But we can condition it compliance with items contained in our adopted comprehensive plan, local ordinances, or official map in place at the time of submittal. Provisions of public improvements or financial guarantees, so you'll have to enter into a developer's agreement to deal with the street improvements that are necessary to be able to support this development. And then satisfaction of objections raised by other agencies. So they have to go through we can condition a plat on going through the process for.
Wetland delineation.
That's a good one. Yep, wetland delineation and our water, I'm blanking. I don't know.
The SWIP?
It's SWIP,
SWIP?
yeah, no, that's the Elm Creek watershed. There we go, watershed. Okay, sorry, I apologize. Apparently it's 8 o'clock is too late for me. So the preliminary plat will show a proposed street and lot layout, lot size and dimensions, proposed easements, existing streets. We'll have typically a location map showing where the property is in context with its surroundings, general contours, significant vegetations, and then we have a public hearing on most preliminary plats. They have to hit, I think it's more than 4. You know what? No, that's not quite true. You have a public hearing on all preliminary plats, but we only do a sign, a development sign, saying that there is proposed development when it's, I believe, more than 3 lots. So it's just the idea that typically when it's a smaller subdivision like that, you'll still get a notice when you're within 500 feet, but it's just less need to put that sign out. And then Planning Commission and City Council do review the preliminary plat. And then the final plat, we're moving from a proposal to the final street and lot layout, final lot dimensions, permanent easements. Each lot is granted a number, a lot and block number. They have to submit final grading and utility plans. Street names are assigned and finalized. And then we also need a confirmation of the vegetation to be preserved, lands to be dedicated, and that is only reviewed by the City Council. Sometimes you'll still see an application that includes the final plat. For example, if there is a preliminary planned unit development and they have to do an amendment before they've gotten their final planned unit development plan in place, that does come back to the Planning Commission. And if we have the final plat, we'll typically include that just for reference, but you're not making a recommendation on the final plat.
Can I ask a quick question on the prior
Yeah.
slide? How often have we rezoned and like changed the future land use map in the past couple of years?
When we did that Red Barn Pet Retreat, that was the last one that I can remember.
And then we changed, so Woodland Hills was a comp plan amendment,
That's right.
and then we rezoned that from RSF2 to RSF3.
And the Cook.
And then, yeah, Cook Lake Highlands, we didn't do a comp plan amendment, but we did rezone it. Anything that's a PUD, we're technically rezoning to something because you rezone to the planned unit development district. 'Cause it's-
So Hope was rezoning too?
Yeah, and then Hope did have a comp plan amendment because there was a small portion of the land that needed to be re-guided from public institution to
Yeah,
mixed
I
use.
remember that.
Yeah, so Hope is another example where we had to do both. And then Fairway Shores had a comp plan amendment to be able to have it guided as conservation residential to allow for lower density, and then was rezoned to a PUD. So yeah, we see, anytime we have a planned unit development, you're going to see that rezoning component. You have the rezoning application, and then you have the planned unit development plan. So that's basically The rezoning is the colors on the map. The PUD plan is the district standards that we're now applying to that parcel. And then we have the plat. And those are I think those are the three that would require, you don't necessarily need the comp plan amendment as long as it's consistent with the land use guiding. But we've seen a couple in recent years where we have had to kind of start from the beginning to get them through the process.
Are we worried about like precedents at all or not too much?
No, so planned unit developments, I think that there's always some worrying about precedents, like they're always, you want to treat people fairly and consistently, but you can as a city also say, well, we liked it here, but we don't like it here for this reason. You tie it back to the site. You can also say, well, we tried that, it didn't work, and we're not going to do it again. Like, the city has some ability to say that we made a mistake and we learned from it. Precedents to a point, but it's not uncommon to have comprehensive plan amendments. It's a living document.
Right.
If it's not doing what you needed to do as a city, then it should be changed.
Okay.
So.
And I'm sorry, I don't want to suck up time. I know we're trying to get through this. The last piece, I think the gap for me is, maybe it's like so obvious and I'm missing it. A PUD is always rezoned. Why?
So the way that we, and I think, okay, well, it's too far ahead, so let's go.
Okay, we can keep it, we can leave it if we need to.
So I'm happy to answer it just in case I don't touch on it. But yeah, so the way that we've set up PUDs in the city is that the planned unit development is a district. It is its own zoning district. So you're always going to rezone to the PUD. That's not necessarily how some cities have it set up. Some cities have it set up as a conditional use permit. I think the benefit of that being is the benefit of it being that a conditional use permit, I think you have less authority to say we don't like this because, again, it's in that yellow. Whereas rezoning is in our green where we have the most discretion.
Sure, yep, makes sense. Cool.
So site plan review, so this is going to be, again, reviewing of a rendering, drawing, sketch of a proposed project's design and layout on a single parcel. So the subdivision is how we're handling subdividing into several, and then the site plan review is much more narrow in its focus. And it can be required or allowed and can be required of allowed and or conditional uses. We require it for anything that's not agriculture or a single family home in the city. So like a church, for example, they would have to do a site plan and a conditional use permit in most of our districts. And then even an allowed use in a commercial or permitted use in a commercial. Thank you. Commercial district. You would have to still do a site plan review, even if you don't need a conditional use permit. So review elements are going to be, again, consistency with our guiding documents, the relationship to nearby uses, location and dimension of buildings, proposed grading and contours. We're also looking at the screening and landscaping, utilities including sewer and storm drainage, parking and access, lighting and signage. So we're typically trying to cover all of those performance standards when we're doing a site plan review. I'm trying to think of an application that we either have coming. I think we have a couple of conditional use permits coming that will require a site plan review component as well. But typically, it's the way the staff report is going to be laid out. You won't even really notice it because it's going to be part of that conditional use review. But it does. I'm trying to think of a situation where we just have a site plan review, and I can't think of one recently where we just did the site plan. Typically, you're going to see a conditional use permit attached to it. Speaking of conditional use permits, they are an anticipated and allowed use within the zoning ordinance. I think there's a lot of confusion with the word conditional use permits. People think that it's not an allowed use. But it is anticipated that this is a use that can be compatible in this district. But the conditional aspect of it is that we may need to add conditions to mitigate the impact of the use. Conditions such as buffers and screening can make the use more compatible, but the use may not be appropriate in areas where these conditions can't be met. So for example, if a drive-through, we typically have that as a conditional use in our zoning ordinance. And we have screening and buffering standards, but let's say a piece of property simply can't meet the standards we have outlined to be able to approve a conditional use permit for drive-throughs, then that typically reflects that that's just simply not a site that can support the drive-through, because we do have stacking rules and things like that. However, sometimes it's the site, we like that site, maybe because it's a high traffic area and we don't think that it really is going to lead to a negative impact. So there might be some flexibility or variance component that the council might be willing to consider. But typically, I'd say that that tends to be a sign that that if the conditions can't be met, that this is not the proper site for that use. General rule of thumb, I would say be flexible with that because we do have some very tricky sites on high volume corners in the city where some types of uses might still actually be the best use of that site. It's just, again, an area where we have some ability to use discretion. It's in our yellow area, but we also want to make sure that it's compatible with the surrounding uses as well. You cannot attach a time limit to CUPs. They run with the land once they're granted unless a condition is violated. So they can be transferred to a different owner, a property owner. There is no sunset clause attached to them. Conditions must be reasonable and directly related to the use. So if we're concerned about the impact of that use to an adjacent residential property, we can't add a condition that, what would be a good condition? We can't add a condition that they add more parking spaces because we're concerned about the impact to the residential property. If we're concerned about parking on the street, we could add a condition about, we can add a condition to require a certain amount of parking, but we just want to make sure that the reasoning and justification is there to address the anticipated impact. So conditional use permits should be approved if they're compatible with the existing neighborhood, conforms with our comprehensive plan, do not endanger public health, safety, and welfare, and meet the applicable standards within the zoning code. And then we have a concept called interim use permits. Not all cities, at least in that I've worked in, have interim use permits, but we do have several. They're very similar to a conditional use permit, but it has a sunset clause is the most significant difference. So within our zoning ordinance, we have conditional home occupation licenses, and it's super confusing because we do call them conditional home occupation licenses, but it's not a conditional use permit. It is an IUP. It's one of the areas of the zoning ordinance that I would like to address because that even just that word right there is confusing, but there's other parts of that ordinance that need to get fixed. We used to, ooh, this is old. We used to have accessory dwelling units as an interim use permit, but we did change that. So now they're either by admin permit or a CUP because we determined as a city it wasn't quite fair to ask property owners to make that type of investment to expect them to potentially have to remove it or have to re-go through an approval process when they try to sell their property. And then we have temporary living quarters, so that's another example. So if someone's experiencing a hardship and they needed to use a trailer to rebuild their house, there is a way to go through an interim use permit to allow for that temporary use. An IUP should be granted when the use, again, conforms to the zoning regulations. The use is temporary in nature and will terminate on a specific date or event. That's the sunset clause. typically our sunset clauses are when the property is sold, when a business ceases to exist. Or you could also say something to the lines, if we approve a use, we can say that it will automatically expire in 10 years. If for some reason we knew that we didn't want to see that use in 10 years, we could add something like that to the permit. The city should not incur additional costs with a use that's being granted an interim use permit, and the applicant must agree to conditions of the interim use permit. So, yeah, the thing with here, the conditional use permit runs with the land. Interim use permits have that sunset clause, and so we have a bit more discretion to be able to check in with the use to see if it's something we want to continue. Our process right now is we have a 3-year review period for every interim use permit. You don't have that for conditional uses in the same way. Some variances. This is a zoning relief mechanism that approves a departure from the standard ordinance. Variances may be granted when there are practical difficulties, but approval is not required. Economic considerations alone do not constitute a practical difficulty. Typically, what you want to see is because of some existing condition of their land. That is why complying with the city ordinance as written is simply unreasonable. Use variances are not allowed in Minnesota. And I'll clarify that a use that is not allowed in the district, you cannot grant the ability to have that use exist through a variance. So, for example, if I wanted to have a car wash business or something like along those lines in a residential neighborhood, or maybe even like a hair salon in a residential neighborhood, I can't, and that's not something allowed in a residential district, then I can't get a variance to allow me to have that hair salon. You would have to add it as a potential use in the district through a zoning ordinance amendment or something along those lines. Mm-hmm. A variance can set a precedent for applications with similar facts and within the same time frame. So that's why it's very important when we do the findings of fact that we are tying the approval to the specific unique characteristics of the land. Because if we have a very generic approval, then someone nearby that might be able to fit those same set of facts, and it's within a couple of months of that approval, theoretically, then yes, we should be treating them the same. So you want to make sure that it is a unique finding of fact, as unique as possible, to avoid that precedent. The other thing is time passing. You can say as a city that, well, we approved it here, but again, we learned from that, we found that to be a mistake, so we're not going to do that. But it's harder to make that argument within about the same year or so. It's just, again, being mindful of our findings of fact. So criteria for review for variances, the state has outlined a few characteristics that we should consider, and this is an area in our code that needs to be revised and updated to match the prevailing state language. So property will be used in a reasonable manner. There are circumstances unique to the property, not caused by the landowner or their predecessor. Unique circumstances are typically interpreted to include physical characteristics of the lot. So this is the wetlands, the slopes, the odd shape of the lot, something that's fairly permanent. I would say landscaping is not the greatest unique circumstance. We have, as a city, said things like, well, we want to retain this landscaping, but the problem being is landscaping does get taken out. So when you grant a variance to allow for a reduced setback because you're trying to save the trees, and then the property owner goes ahead and takes out those trees anyways, but you've granted them the variance that runs with the land. So that's not the best idea. It's a little harder to do that with a wetland. But wetlands do change as well. And then finally, the variance will not alter essential character of the locality is another a characteristic in the review. Conditions can be applied to a variance if granted, but they must be directly related to the impact created by the variance. So we can't, when you're looking at a larger application, it can be easy to say, oh, we'll grant you this variance if you do this, but if it doesn't have anything to do with the impact of granting that variance, that's not the way to go about it. It's not the same as a PUD negotiation.
Quick question.
Mm-hmm.
Do we have like a library or somehow documented like list of variances we've approved and and that maybe
Yes.
also is a broader question for comprehensive plan amendments and whatnot, because going back to the role of seeing the past, learning from it, and applying it to the future, it's kind of hard to wrap your arms around like what's happened before all of us were here, you know?
Yeah, I do try, as part of the staff review, we do try to consider as part of what we're talking about, our conversation, like, well, we did that though for this development and it hasn't gone well. I think another example is Bass Lake Crossing, we allowed building setbacks as low as 5 feet on the side, and then we just through discussion, through the experience of those people living there that really don't like the 10 feet separation, they wish they had a bit more separation, and just hearing that feedback, that's kind of been what has helped us decide that that is a rule that we don't want to reduce lower than 15 feet going forward. And so we've documented that as part of our process for PUDs now. So all that to say, we do have a master list of every planning project since about 2004, I believe. And then we have a historical list for the records that we do have prior to that. Our record-keeping skills are less than desired prior to about 1990s, I would say. So there's some information we simply don't have that I believe that it doesn't necessarily reflect that it didn't happen, but it's just a matter of this is the documentation that we have. I do believe we have a master list for variances. I don't know the last time we updated it. We probably would have to update it. But we do have a few of those trackers that we do for our record to be like, oh, this property has this variance, this property has this DUP.
Yeah, and I know I'm not trying to add work, it's just, the volume, the workload, the amount of activity, it will keep building, and it'll be up to us and our function to see what's working, see what's not, understand the volume of things we're hearing and seeing. So I was just curious. Okay, we can keep moving.
But yeah, I would say if we ever have a variance application, I think that is a perfect question to ask us if we haven't outlined that in the staff report already, is have we ever granted a variance to this? And we can certainly look at our records and let you know. So far, our variances in specific, I haven't really had too much learnings from, other than that landscaping example I just provided, where we granted a variance based on landscaping and then they ended up removing said landscaping. That was pretty disappointing. So again, I learned from that that's not something that I think we should base our findings on in the future. Or if we do, there needs to be a clear condition that they can't remove the landscaping and are responsible for replacing it if it dies. Something like that. You have to have a little bit more teeth to it.
Yeah.
Conditions can be, okay, we already talked about that. So I think that's a very valid question, Commissioner Lind. And we do have documents that we can search if that ever is a question in the review of the application.
Okay.
Planned unit developments. So again, a PUD in the city of Corcoran is a rezoning request, and it's to review several buildings and/or uses as a unit. So this is within our Corcoran zoning code, section 1040.140. And the idea is it's supposed to promote creativity and efficient use of land. It allows flexibility in regulations and a mix of land uses. It's useful for difficult sites with many natural resources where compliance with by right zoning can be difficult. And it's also useful for when market conditions are changing quicker than we can update our codes. And so we're able to respond to a developer's a developer's real experience with the market and trying to meet a need that there is, without necessarily having to redraft our zoning ordinance immediately. We can kind of deal with it as a one-off solution. So a PUD should provide benefits to the city and users not obtained through straight zoning. So for example, we have the PUD policy, or public benefit policy adopted last year with 27 public benefits that we've identified. And they should meet a number of those. We consider the size of the PUD, the constraints of the PUD, and the extent of the flexibility that they're requesting in exchange for the proposed PUD benefits. And ideally, we should see something that's fairly balanced. This is, again, a legislative decision because we treat it as a rezoning. So feel free to let me know if there's any questions on the planned unit development. I think it's a negotiated zoning district is the best way that it's been described to me. It's going to be something where we have our underlying zoning district and then we have it called out in the PUD plan where it is that we're deviating from our underlying standards. And so some of them, it could just be fairly minimal changes. I would say Fairway Shores is an example where we really didn't have that many flexibilities being requested. But we had a number of benefits being received, but we have also other PUD examples such as Hope where it was significant departures, partly because I think our mixed-use development, mixed-use standards are incredibly outdated. They were drafted in about 2004 and have never been used, and this was the first time using it, and I was not a fan of that district. So I would like to look at that because I don't think it meets, I question if it really met some of our current goals, and I question how it interacts with our Northeast District Plan overall. I think there's an area where that needs to be simplified and evaluated. But again, the PUD application allowed for us to respond to an existing applicant, an existing proposal, without having to make those decisions right away. We're able to deal with it as a one-off and then kind of put it on our list of things that we need to review as a city. So for procedures to consider for the Planning Commission, we loosely follow Robert's Rules of Order. I say loosely because we do the motion, we do the second, we do the vote. When there's a question of how we should proceed, we try to revert to these rules. However, I would say that we're also fairly casual in our meetings as well. And I think that we like that about our culture, but it's still good to have an idea of the Robert's Rules of Order. Let me know if you need any resources as to that general rule of thumb for that. I found a cheat sheet today that might even be helpful. And I'll go in the next slide, we'll talk a little bit about the meeting process, which will have some of that in there. It's also important that we obey open meeting law. This is a rule that says that we must be open to the public. We must notify of our meetings and when a quorum is anticipated. So even if it's not a meeting, but you wanted to do a happy hour as a group, it's not that you can't do it, it's just that we need to have a notice saying where you'll be.
Fun.
But we certainly could do a happy hour, but not at City Hall. So you have to notify that. So we have some open meeting laws. You really aren't responsible for doing the administration of open meeting laws. That's part of staff's responsibilities. It's just something to be mindful of. And then we also have compliance with the 60-day rule. So that being a rule in the state of Minnesota that government entities have 60 days to respond to land use applications or any type of decision having to deal with land. So we do have some ability to extend it. Preliminary plats are automatically extended to 120 days. And then the city can extend extend any application up to 60 days more one time. And that's our only extension that we can grant ourselves. Otherwise, it has to be an applicant making that extension request. And we cannot extend final plat review, because the idea being we already had 120 days to review the preliminary plat. So we have a hard 60-day rules for final plats. So that is why when we say things like we have to get this application reviewed, we can't just postpone it to next month because we're running up against that deadline. So it's important that we do meet our meeting dates unless we don't have anything on the agenda. And that's why sometimes when we've had instances where we didn't have a quorum, we had to do a special session right away the next week so that we could still hit the timeline.
So does that mean that when Corinne invites us all to her birthday party, she's gotta invite the whole city?
No, we just, not.
You just have to notify.
So
We
Jay,
have to do a quorum notice. Yeah,
I'm being facetious,
I
I'm being
suppose
facetious.
theoretically, I guess that's one way to look at it. But we would have to notify. We'd put a notice of a quorum, potential quorum, and then we would say what it is, and then the time and place. And we could probably even say in their official business is not anticipated. But I think the idea being if you do discuss something, we need to make sure that that is that had been properly notified. So that's just, if you do decide to do that, maybe we should talk with the city attorney first. But there some other instances have been like if we have an open house for a community engagement component or a community event such as Night to Unite, and we are anticipating that all the council members are going to attend, or at least 3 of them, or at least 3 commissioners, then we do need to post the event, the time and the place, and have that, make sure that that's clear. There's a potential for that quorum.
the city administrator, Jay, invited everybody to happy hour at the station on the meeting that took place for St. Patrick's. And he just notified it during the meeting. So all that to say,
Yeah, it's
I don't
just
know who
basically
took him up on it,
The
but
meeting location just changed, but there was a proper procedure as to where you needed to be to understand that the meeting location could potentially move. But yes. So yeah, there's a proper notice process. So so you are responsible for knowing the open meeting law. It's just it's really a communication with staff, and we're the ones that take care of making sure that the notice gets up in time. Another thing to keep in mind with the open meeting law is you do not want to email each other. You can email one other commissioner without it turning into a meeting. They have determined that an email exchange with all commissioners or all council, whatever body the email is between, does constitute a meeting. And if you haven't done the public law for open meeting law, we can get into trouble if there's any discussion. So you want to make sure that if you do reach out to another commissioner, if you have a question, if you want to get their insight on something, you can reach out to one other planning commissioner. You do not want to do an email to the group. That's also why when staff emails you things like the packets, we blind CC all of you so that if you do hit reply, it doesn't turn into an open meeting. Yeah. So
I don't even think any of us have each other's emails.
I do provide with your commissioner orientation, when I gave you that jump drive, it had the emails at that time. You probably don't have 3 email address, but I can certainly give that to you.
Whenever I've needed somebody's, I've emailed you. So
Yeah,
I think
that's certainly a way to do it too.
Works just fine.
So I can talk with you individually all. That's not a problem to talk with me before a meeting with questions. It's more of the discussion between you 5 specifically that it turns into an area where we need to be mindful.
And so just a couple things, and just my learnings over the past year are like, if you determine you can't be a liaison anymore, you want to reach out to a commissioner. I didn't have anybody's email, so I emailed Natalie. And then also, would you say that it's helpful to let you know if you're not going to make it to these meetings, because you want to make sure that you have a quorum?
Yes, please let me know immediately if you
Okay.
can't make it to a scheduled
So make sure that
meeting.
was said too.
Yes, yep. And then typically, once I receive one notice if we can't make it, then I send an email saying, please confirm you can make it. Just because the couple times where I'm like, oh, we still have a quorum, it'll be fine. It real quickly turned into, we don't have a quorum.
Right.
So now I've just learned that if one person can't make it, it's a good time to just check in with the group. So a meeting procedure, so typically the chair will announce an agenda item and clearly state the subject. The staff will complete their presentation. I do try to keep it fairly minimal, anticipating that you've all read the agenda packet. At the same time, particularly if we have a large public audience, I do try to hit the high points of the staff report, not in the anticipation that they probably didn't take the time to read a significant staff report, or if they did, they may have skimmed it. So basically the staff presentation should be enough for them to understand what we're talking about, but it should just be a quick review for you, because it's not going to have every detail discussed in the staff report. And then if it is a public hearing, the chair will open the public hearing, take testimony, and then close the public hearing. And then at that time, typically, we have clarifying questions. And actually, I should back up. Staff presentation sometimes is followed by an applicant presentation. Sometimes it's really informal, and they're just like, hi, I'm the applicant, let me know if you have questions. Other times, they have their own PowerPoint of some topics that they want to hit, that they want to further explain, maybe something I touched on the staff report or something along those lines. But then we get to the end of the public hearing, and then that's typically an opportunity for staff to answer any questions that came up during the public hearing, answer any initial questions from the planning commission. And then this is kind of where we loosely follow things. Per Robert's rules, the chair should then invite a motion, kind of right off the bat, to frame your discussion. And then once we have a first motion, then the chair invites a second to that motion. And then at that point, the chair would restate the motion and preside over discussion and debate by members. And so members should be recognized by the chair before speaking. Again, this is kind of where we're fairly flexible. We try to, we don't necessarily have to follow this rigid of a rule. The benefit of making the motion right away is, again, it helps frame the discussion. And the second doesn't even necessarily need to say, because yes, I support that motion. It can just be second for discussion, with the idea of you want to have that, start that debate. So that's the benefit of doing it like that. I have not really seen it done like that in a planning commission meeting yet. After all have spoken, the chair should then repeat the motion on the floor, and then the chair calls for a vote on the item, and then your options are yes or aye, no, or you can abstain. I would recommend that we use abstain very sparingly. This should be really only when you have a conflict of interest. And when I say conflict of interest, it's when you have a direct financial tie to the decision. So maybe your husband or spouse, I should say, is applying for a conditional use permit for an accessory structure on the property. At that point, it would make sense as for you to abstain, because you would have a conflict of interest with that decision. So then the chair confirms the result of the vote. Chair can seek the clarification from individual members of their votes if necessary, and the motion carries by affirmative vote of a majority of members, otherwise it fails. So if the motion was to approve a resolution and it got a 2-3 vote, it fails, but we still need a motion in the affirmative. So then you would make a motion to recommend denial to get the majority vote, and that's the motion that carries, and that's the official recommendation. And then we're almost to the end. Last 2 slides here. So just talking again about legally defensible decisions. So and this ties back to the procedural rules and substantial rules. So the use of proper procedures is important. And then subject matter decision, the jurisdiction is, did the body decide a matter that it is empowered to by statute or ordinance to act on? The proper procedures, did the body follow proper procedures such as the open meeting law, the public notice, the opening and closing the public hearing? Did we create a record of decision? And then we need to make sure that our decisions have the application of property standards. Did we apply the proper standards in making that decision? Are we referring to standards for the rezoning, a CUP plat? What exactly did we use to guide when we made the record of decision? I'm just going to kind of jump through here, Ashley.
May I ask one quick
Yeah.
question? In regard to the use of proper procedures, after the staff presentation, if an applicant is not allowed to give a presentation or address, is that a deviation from the proper procedures? Do you know what I mean? Would that be a legally defensible, like, claim, right? They could be like, hey, you denied me the right to speak, but technically it's not.
Yeah, I would say, I would want to get the city attorney's actual thought on that. I would say it is poor practice to not let an applicant address the commission when they're in front of you. They should have the ability to speak and explain their stance. At the very least, that's poor practice. And then whether or not we have the legal basis to say, no, you're not going to speak any further, or not going to speak at all. I would want to speak with the city attorney on that. I don't know the answer to that. I just know our practice is to make sure that the applicant has a chance to speak. There may come a point during your deliberations where you say, no, at this time we're not going to take any more comments. We're going to finish our deliberation. But all the more important for you to be able to say that they've had their chance to speak on the front end. So yeah, and there's a case, Hoyt et al. Versus City of Minneapolis, that it's interesting in that it's a perfect case on what not to do as an elected or appointed official. Basically, from this case, there was a counselor who had emails, documented emails that made it clear he or she, I don't know off the top of my head, but they had made the decision on not supporting a project before it had really gone through the public hearing process, before the facts had been presented to them, and they had several emails where that stance was clear, and they were found to have violated the due process standards for that applicant. So it's important that you do not make up your mind prior to a public hearing. You want to be open to the evidence presented at the hearing, both through the staff presentation, applicant presentation, as well as the concerns and objections that may be brought up by the public. Not all concerns will have a valid objection that we should deny an application for. But you want to make sure that you're still giving people the floor so that they can raise their concerns. And sometimes it's something that we can easily adjust in the plans, especially when we have some discretion. You do not want to advocate for or against a matter for which there will be a public hearing, and you want to remain an impartial decision maker. So it's okay to have an idea of what way you're leaning before the meeting. You don't want to be on any kind of record saying that this is how I will vote. And really that should be a personal matter, and you should be open to changing your mind based on the findings of the hearing. Okay, so yeah, important to avoid advocating for a position until all information has been presented to you. The ex parte contact, so that's communications between decision makers. And then conflicts of interest. Again, this is defined, when we're saying conflicts of interest, we're defining this as a direct financial tie to a decision, and then discussing projects and meetings on social media. Again, you don't want to be on an official record anywhere saying, this is how I plan to vote, or this is why this project should go through, things like that. And that's what we have for the presentation. Thank you so much for bearing with me. I'm sorry I got tongue-tied a few times. And
Are
now,
you-
go ahead.
I'm sorry, are you gonna mail that out to us? Could you email that out to us?
I can email it too. Yeah, definitely.
I think that'd be nice to have.
Before we play Jeopardy, may I just ask one question?
Sure.
Sort of taking back all the way to the historical,
Yeah.
but when can you recall off the top of your head, and if not, don't worry about it, when the last time that there was like a modification to the zoning process that most cities do, whether it's like a new zoning, like typical are residential, commercial, industrial, those are pretty standard for every area. When is the last time in our, like, in history when there has been a change to that whole kind of process?
For us, for Corcoran?
Not for corporate, like as a whole, like in the like city planning genre, have there been any updates or modifications where we're like, hey, we want to build the best cities we possibly can, and we have learned that we need to like make this change or add this in order to do it? Has there ever been?
So there's been different theories that have come into play over the decades. I could send you some information on the different theories that have come out. And I would say right now it's the prevailing theories are kind of a mix of each one.
Okay.
Like, okay, there's like the advocate theory where planning should be putting the needs of the disenfranchised, making sure that that's front and center with our model. And then there's others where, I'm trying to think of some examples off the top of my head, I apologize. But yeah, there's basically different theories that have come into play. And I think the last big theory was probably around 1980s, 1990s. And then we have like other trends that come into play. So new urbanism was a huge trend when I was going through college. And then right now, as someone who went into environmental policy for my master's degree, resiliency, sustainability, those are some like new focused areas where we're trying, and then there like the other buzzword is diversity, making sure that things are like racial equity and diversity, and making sure that we're creating cities that allow for that don't hinder one group, things like that. So I would say the zoning, like comprehensive plan and zoning, that model has prevailed pretty consistently since the 1916s. But something that has changed is at one point there was this desire to move to a form-based code. So you saw a lot of cities going that direction and less focus on the use, more focus on what it looks like. And then from there, again, the idea of picking and choosing, now we have codes that have a little bit of both. So you still have some use constraints, but the form is a huge, bigger concern than older styles of code. And then trying to think of other things that have changed through the years. And now you're starting to see like this push for mixed use, and so those are kind of fairly new districts that have been established. It kind of happened naturally in like city core areas, but now with a push realizing, oh, mixed use does make sense in terms of making sure that people don't necessarily need to get into their car to be able to get to basic uses or basic services such as the grocery store, and so trying to encourage that through a mixed use district. So. Yeah.
Okay.
Is it an evolving process?
And then my final question related to that is that just done, that ever-evolving process is done as a city individually? Yes? Like, I guess I mean, like, so I'm using the storage for an example, right? Like, we did a comparison. Like, look at how all of the other cities around us are doing it. But, like, it just takes one city to say, we could do something differently. The city does not have to under any other governing organization, they don't need to go through some sort of process in order to say, okay, we want to evolve this way in planning.
Mhm. So as long as it meets, as long as it's,
Legal.
as long as,
Legal.
yeah, legal process, so you don't want to, so there are certain, like, protections that certain classes have, we wanna make sure that
Yep.
we're abiding by that. And then we want to make sure that we're treating everybody consistently, that we have a rational basis for the regulations we put in place. But yeah, we can be fairly creative with our regulations. I think you'll find that on a staff level, I would prefer to take a look at what other cities are doing to see, okay, that worked well, or ooh, I like how they have this caveat. That seems to be, you know, it's really helpful where we're at in our development timeline. We have the opportunity to really see what has happened with neighboring cities, and maybe there's aspects that we do like, and then try to correct for the aspects that we don't like. So yeah, I would say the last time that we had a big update to our zoning ordinance was 2004. We are probably long overdue for a comprehensive ordinance. It's just very expensive. And so you tend to have this kind of limping along, like edit this portion and limp along. The problem with that being is sometimes you have aspects of the code that talk to each other and you don't realize, you didn't catch, like, oh shoot, that now impacts here, and now we're in a bit of a pickle because that's not what this part of the ordinance says anymore. So that's the downside of kind of doing one-off corrections as we have time. I know that recently several cities that are fairly developed now, and they're going back and refining their code, and so some of them have completely redone their zoning ordinance and just did it comprehensively, but they're also responding to less development applications where they have the capacity to do that.
Great.
So,
Okay.
yeah, sorry, I don't know if that answered your question too
No,
well,
it
but-
did,
Okay.
yep. It did.
Well, perfect. Does anyone else have any questions before we get into Jeopardy?
Just to comment on that, I think, one of the big things is multimodal, and you mentioned walkability.
Mm-hmm.
And, there's a lot of, people talk about it a lot, but how do you actually, get that to happen?
Mm-hmm.
I know I've read the downtown plan, and it sounds like a really nice plan. And
Mm-hmm.
they're gonna do a grid kind of for the housing around there. I
Mhm.
think they're gonna have a boulevard through the main
Mm-hmm.
kind of commercial area of the city, so that would probably be more walkable.
Mhm.
It wouldn't be on County Road 10 or 116 that,
Mhm.
kind of runs through there. It seems like a fairly small area,
Mm-hmm.
so I'm not sure how far out that goes and how the connectivity goes. I know we talk about parks and trails. I
Mhm.
sat in on the city council meeting, and they were talking about the ability to maintain trails, especially in Corcoran, where things are really spread out. But I know I live right off County Road 19, and when they did the county road project, and then they put a trail along there, that trail gets a lot of use. But then I go up into Hanover, into Wright County, and they actually, clear their trails of snow in the winter, and Hennepin County doesn't.
Mm-hmm.
So my husband and a neighbor actually get out there and they clear the snow until the plow, gets too carried away and dumps a 6-foot pile on it, and then of course they can't get through that.
Oh, no.
One question besides just an observation.
Mhm.
I know a lot of residents, they have tractors, we're a rural community. Is
Mhm.
there any ability for people to volunteer to maintain, and this is probably more of a Parks and Trails question than a Planning Commission question, but do we allow volunteers to help with maintenance?
I
If
don't.
That's an issue.
I don't know how that would work with liability. I think that could be a question for probably either Kevin Mattson and Jay Tobin, the city administrator, in terms of the logistics of that. That'd be my concern, it would just be the liability of that, but we have had some talk about, I think you were at the meeting where they talked about, would it make sense to have some kind of a contract with HOA, with HOA contractors who are tasked with taking care of the trails, and would the city then maybe provide a little bit of a financial stipend to allow for that, so that we kind of have a middle ground approach versus having to have more staff to deal with the trails. So I don't want to say that it isn't possible, I just wouldn't want to speak to it right now. But I think it's a good question,
Okay,
so,
thanks.
anyone else? So I know it's a lot of information, so there is a buzzer in front of you. And I will try, they're all different sounds, so it'll be, so you may have to also raise your hand so I know which one's first, whoever presses it. But the goal here is just to try to have an engaging way to go over the material that we just ran through. I know it's a lot, and I'm happy to pass on the presentation in an email so that you can look at that at your own time. But I know the last time we did this a couple of years ago with the commission, it seemed to be a fairly engaging way to kind of recap everything, so.
And I won't buzz in a lot, because I played it before.
So she has a 10-second head start before she hits her buzzer. So yeah, we have the 1, 2, 3, 4, 5, 6 categories. I think maybe the chair should just start us off then.
Okay, we'll pick historical background for 1,000.
For 1,000. Okay. So, in this 1926 court case, the U.S. Supreme Court upheld zoning as a police power.
What are we supposed to say, true or false?
You buzz
Oh,
in,
you buzz in, and then the jeopardy is like, what is such and such and
and then you
such?
say the thing.
Yeah, the thing.
Yeah, I don't remember.
So this is a
pretty
1926
specific.
court case that the U.S. Supreme Court upheld the zoning as a police power.
Wow. The village of Euclid, or
Oh,
Euclid,
Where's the Ambler Realty?
Euclidean
Yeah,
versus
yeah.
Ambler Realty.
Yeah,
Nice.
yeah, it's a good job.
Pretty good.
All right, so actually, do you have a piece of paper to keep the score? I forgot about that.
I got it.
You got it? Okay, so 1,000 to from it. And then, so then that puts us back to the board, and I think that means you have to do the next one too.
Planning basics for 200.
Okay. This board was created under the presumption citizens should be involved in the review and recommendation of land use.
The planning commission.
Yes, that's correct.
Well, that's a fun sound.
Yeah.
I want
I
to hear
like
what
that.
everybody says.
I had to test this all out last night to make sure they still had the batteries were still good in them, and my toddler was like, just like ran to me like, what is happening here? I was
Yeah,
so
the sounds,
excited.
the colors, oh my gosh.
But effective word. Okay, so then go ahead and choose the next one then.
Oh, I get to do it?
Yep.
Okay. Planning basics